Welcome to the Governing Conversation series. I'm Professor Ann Washington. I'm founder of the Digital Interests Lab at NYU and co-created by my lab and the Information Society project at Yale Law School. The Governing Conversation series provides reflection and critical perspectives on how we organize societies in the light of emerging technologies. Today, we kick off the Access and Accessibility series in collaboration with American University, both its Institute on Disability and Public Policy and AU's Internet Governance Lab. Disability law and the internet is the topic today, and I will leave you in the hands of our competent moderator, Dr. Tina Kempin-Reuter. Over to you, Tina.
All right, thank you so much, Professor Washington, for that kind introduction. As she said, I'm Tina Kempin-Reuter. I'm the director of the Institute for Human Rights at the University of Alabama at Birmingham, and also an associate professor in the Department of Political Science and Public Administration and the Department of Anthropology here at UAB. My area of focus are rights of people with disabilities, with a lot of focus on international and then grassroots level. For accessibility, I am a white woman with long blonde hair, wearing a dark blue sweater and striped blouse. And as I said, I'm zooming in from Birmingham, Alabama, and my pronouns are she, her, hers. Before we start this conversation, I would like to ask my panelists to please briefly introduce ourselves. And I'm just going to go by the way I see you. So I'm going to start with Doron, please.
Hi everyone, and thanks so much for having me. My name is Doron Dorfman. I am a white man with dark hair and dark glasses and a bottom-down light blue shirt, sitting in front of a white cabinet with a big smile on my face. I'm talking with you from New York City, and I'm an associate professor of law at Syracuse University College of Law. Starting in fall 2022, I'll be joining the faculty of law at Seton Hall Law School in Newark, New Jersey. And I'm very, very excited to be here with you. I do research at the intersection of disability studies, law, and psychology, and I look at the way people experience disability law and also health law and how it comes up in their everyday lives.
Thank you, Doron. Oh, sorry.
No, please.
Okay, sorry about that. Thank you, Doron. Blake, I'll have you go next.
Thanks, Tina, and wonderful to be here with you all. My name is Blake Reed. I'm a clinical professor at Colorado Law, where I direct the Samuelson Glushko Technology Law and Policy Clinic and serve as an initiative director, our faculty director at the Silicon Flatiron Center. And I should say I'm here on behalf of myself, and all the opinions I express today will be my own and not those of any of my other affiliations or clients. I'll say I do a lot of work at the intersection of disability, technology, and telecommunications, intellectual property, internet law, that kind of thing. Before I engage in the description, I just wanted to point folks to what I thought was a really interesting editorial by Thomas Reed, who's an audio description specialist or professional, on the sort of dispute that's happening about these kinds of self-descriptions and the reasons for engaging with them. And there's some divide, note that's described in this article among members of the blind community and about the need to do this. And Thomas makes the case that white professionals often lack motivation or reason or occasion to describe themselves, and that's uncomfortable, and that it's really important to do that, both as a matter of accessibility, but also as a matter of unpacking whiteness. So in deference to that request, I will be happy to indulge and say I am a mid 30s, I guess I'm an upper 30s white man with brown hair and wearing dark glasses. I have a goatee, a blue flannel shirt, and I have some bookshelves with a whole bunch of Legos and books and Star Wars toys and guitar pedals and a big flag that says TLPC behind me. Back to you, Tina.
Thank you, Blake. Last but not least, Arlene, could you please introduce yourself?
Hi, everyone. I'm very happy to be here with my esteemed colleagues, Doron, Blake, and just meeting Tina. I was very happy to be here. This topic of access to the digital world by people with disabilities is an area I've been very devoted to and I'm obsessed with. And it is a very, very hot topic in disability and somewhat surprisingly still a very controversial issue. I was the founding directing attorney of Disability Rights Education Defense Fund, a national law reform organization centered in Berkeley, California, with an office in DC. We were very involved in basically the passage of all the various laws culminating in the ADA in 1990. I was very privileged to be a part of that. And I also brought one of the very first, if not the first, case that recognized that, the Netflix case, which recognized that web qua web companies are covered by the ADA. So it's a continually emerging topic as technology gets more and more platforms, and I'm really happy that this conversation is happening. I am 71 years old. I have long gray hair, and thanks to COVID, it's all gray now. And I am sitting in my home in Berkeley, California, where our offices are, Dreadif's offices are. So welcome.
Thank you so much. And thank you again for everyone for joining us today. And thank you to the Information Society Project, the Digital Interest Lab, and the Institute on Disability and Public Policy for inviting us to have this conversation today. As some of my colleagues already alluded, this is a really hot topic. From a disability perspective, the internet has mostly been a blessing with some downsides, with lots of questions arising with regards to accessibility, inclusion, and empowerment. So today we really want to tackle these questions and shed light on the legal aspects of ensuring accessibility on the internet, talk about questions of responsibility of how to make this happen, and dig a little deeper by talking about COVID-19 and how remote work and remote social interaction has made these issues more pressing than ever. I want to start with you, Arlene, if you don't mind, and ask you to briefly summarize what kind of strides have we made with regards to the legal framework and the standards for accessibility of the internet, and what were some wins for the disability community, and what are some continued challenges?
So when the Americans with Disabilities Act was passed in 1990, for those of you who are not familiar with it, it's a comprehensive law, the idea being that people with disabilities should have access to the society that we all take for granted. And that means government entities, whether they're state entities, local entities. It means public accommodations. It means when you go out you leave your house, where do you go, and can you get in, and more, and are you served correctly, and are you treated as an equal citizen, and more, of course, all of these things have moved to the internet. So I just want to give a very brief background on why this area under the ADA is even controversial at all. In 1990, when we worked on the ADA, the big newest thing was the inclusion of public accommodations. And it's a little bit of a misnomer because in order to be public, you have to be private. So it's all the places in the community that you access on a daily basis. And so, there's a lot of interesting stories about how the definition of public accommodation came about. I can't really get into those now, but anyone who's interested can contact me later. But there's a list of public accommodations. And basically, it's defined as the following private entities are considered public accommodations for the purposes of this title. And then it's an actual list, and it's an inn, hotel, motel, and other places of lodging, restaurant, bar, and other places, establishments for food and drink, motion picture house and other places of exhibition, auditoriums, convention centers, a bakery, grocery store, clothing store, laundromat, dry cleaner, bank, really, and it goes on, a terminal, a museum, a library, a zoo. It goes on, and we were really trying to just come up with every single place that one could possibly go to give a list of public accommodations. And most of the list includes or other similar establishments, so that it's not completely limited. So my involvement started, and I think it kind of interesting because it does kind of coincide with the history in this area, is so I was a Netflix subscriber, and like all of us were excited when Netflix came out. And in 2008, Netflix started streaming. And I was excited, and as many people across the country were. And I would, go, okay, great. My subscription now covers streaming, put on, I want to watch this. And there'd be no captions. And I'm a caption user because I am hard of hearing. So I'd be like, I can't watch that. I can't watch this. I can't watch that. And, of course, was not alone. There were millions of people. There's 36, and that's the low estimate, million deaf people in the country. And we were not having access to this brand new, exciting technology. So I immediately thought of like, well, we need to sue under the ADA. When I originally brought up that topic with all my colleagues and all the government agencies, they said, we can't, because the internet's not covered by the ADA. And I said, but that doesn't make sense. And along with the list that I said to you, places of public accommodation, there was also in the legislative history a very important note that we've relied on a lot that said, but we want to keep up with technology, because we realized in 1990 that new things would come along. So the big controversy in this area has been, what is a place of public accommodation? And to the defendants, these public accommodations that resisted, it means a place, bricks and mortars. You can touch it with your hands. It's partially a generational divide as well, because if you ask people of a certain age what a place is, they think it, you get to knock on the wall or the window. And if you ask people under a certain age, they'll say, well, the internet's a place. I visit it all the time. So we brought the Netflix case, and we started negotiating with Netflix. And what I've found since then is that everyone assumes captions were always part of streaming. Well, let me tell you, it was a very, very hard fought battle. And basically, we filed in, I think it was 2009, and the consent decree, was in 2012. And that was after a full court hearing about this question. Can you be a place of public accommodations under the ADA if you are only on the web? And there's much more to be said about that. Since that time, not only have the lawsuits proliferated, because so much of the internet is just not accessible to people who are deaf and blind and other people. And so the area has proliferated, as it has the technology. So now we have virtual reality, we have kiosks, we have I listen to them every night. What are they called?
Podcasts.
What?
Podcasts.
We listen to the podcast every night, yeah. And we have all these things where there's no place, but they're central to how we live. So I'm going to pretty much end there right now, but I want to say that in all these areas, we've made progress, but even the simple area of whether the ADA covers internet, which could be podcasts, which is not, the people don't think of as internet necessarily, but places where we go for entertainment and the kinds of things that, and goods and services and all the kinds of things that I listed in the list, many of those are on the internet. And there is still a split, and it's called a split in the circuits, which are the courts that decide after a trial court, the appellate courts, and there's still a split. And it's not even a consensus in the courts that the internet's covered. And just to say that if the internet's not covered, and if all these various things that I've just discussed are not covered, the ADA has lost its meaning, because the whole idea of the ADA is equal access. And to not have access to the internet, I'm sure there's no one on this webinar right now or anyone in the future who would argue that it's not essential to daily life. And so in addition to litigation, the other areas that we're really fighting for, we still don't have regulations from the Department of Justice, which is the implementing agency. Totally controversial. We've been waiting like 14 years since their first notice, and we still don't have any regulations. So something that seems very obvious, I think, to disability rights lawyers and to disabled people, certainly around the country and around the globe, it's definitely an international issue, is still a controversial area. And we want to fix that.
Thank you so much, Arlene. I actually, you mentioned like the importance of the increased technology, additional services, additional handheld devices, information communication technology, the Internet of Things. Blake, do you want to chime in here and tell us a little bit more about how that has affected and what kind of legal implications there are?
Yeah, absolutely. And I'm so glad to have gotten the incredible potted history of the ADA from Arlene, who is just an amazing leader and figure in that movement. So Arlene, thank you for the detailed share there. The way I have always thought about the ADA is it is a general purpose commitment to make society accessible, or to require that society be accessible. And Arlene described the struggle of sort of conceptualizing the web and focusing specifically on the web as part of society, right? In a sort of metaphysical way, right? Like, how do we conceptualize this thing as part of the society that Title III of the ADA was getting after, right? And there's another legal movement or another legal tradition in the US that I think gets somewhat less attention than this, but this is the FCC's tradition in telecom law, which actually takes a totally different approach. Rather than saying, we're going to focus on accessibility generally, it goes kind of technology by technology. And actually, the FCC's tradition actually predates the ADA by a fair bit, starting back in the 1970s when the FCC was working with broadcasters to get closed captions engineered into the specification for broadcast television. And it continued. One of the first kind of pieces of legislation in this space was the Telecommunications for the Disabled Act of 1982, and then the Hearing Aid Compatibility Act of 88, which started to require telephones to be accessible in the sense of working with hearing aids. It was very specific, very detailed in that regard. And we've had a panoply of regulations that have and laws that have come along since then. Actually, part of the ADA, I think a lot of like disability law classes sort of go through Title I, Title II, Title III of the ADA, and they skip Title IV. And Title IV is actually this telecommunications provision that creates the relay system, charges the FCC with administering the relay system that deaf and hard of hearing people often use to communicate by funding the provision of ASL interpreters and captioners, basically to serve as to sort of grease the skids for phone calls to happen. And then it goes on. In the Telecommunications Act of 96, we get closed captioning regulations regulations that apply broadly to broadcast and cable television. Again, kind of owing to the FCC's tradition of regulating the video programming marketplace. The FCC is kind of a logical place to put that. And then we also see the FCC starting to regulate communications technologies. We get requirements that basically the phone system be accessible, that networks be constructed in accessible ways, that the equipment you get at your house, the handset, be accessible, that customer service lines be accessible, and that kind of stuff. And that kind of culminates in the most recent piece of legislation we have, which is the 21st Century Communications and Video Accessibility Act, which President Obama signed into law in 2010, which actually tries to bring the FCC's regulations into the internet and starts thinking about, okay, how do we make internet protocol delivered video programming accessible? How do we extend closed captions to that? How do we extend accessibility requirements to messaging applications, to voice over IP communications, to video conferencing, and all of that sort of thing? So I think it's pretty interesting that we have these two long-running traditions in disability law. The ADA kind of coming at the internet from a how does the internet fit into society perspective, and the telecommunications tradition coming at it from a how do we make all the constituent technologies that kind of go into the internet and the mediums that led up to the internet, how do we make them accessible? And I think the exciting and interesting thing is we're kind of hitting a place of convergence with these things now, where a lot of the things that we're talking about trying to cover under the ADA are the same things that the FCC is talking about. We're talking about emerging technology. We're talking about the Internet of Things. We're talking about expanded augmented reality, virtual reality, et cetera. And what's the right framework to tackle these things? And so there's all sorts of interesting legal challenges that are getting propelled by the technology that we're seeing evolve right now. And I'm sure we'll get into that more here.
Arlene, do you want to briefly chime in?
I just wanted to say that, of course, I agree with everything Blake said. The biggest barrier we had in the Netflix case is the Netflix saying, oh, that's all in the FCC. And the FCC at the time, just to simplify it, said that if you're a streamer and something's already been on television, you have to have it be captioned. I'm talking about captioning in particular now because of my case. You have to have it captioned streaming. And we were saying, yeah, but we don't want to be limited to what was on television, whether it was captioned or not. So it's interesting that this beautiful convergence that Blake has described has actually been one of our biggest barriers as far as defendants arguing it's a technological issue, the FCC is in charge of that. And the way we got around that argument is called primary jurisdiction, they said, is with the FCC, is by saying there's a real big difference between the FCC technological approach and the ADA, and the ADA is a civil rights statute. And we're not bound by what the, in scope, because we're a civil rights statute. And that's the, the mantra of the ADA.
Thank you. Yeah, I mean, when we talk about disability, right, it's not just that it's like different agencies that seem to be, or different laws that apply, but it's also that disability in itself is incredibly diverse, that people with hearing impairments do not have the same needs as people with who are blind and vision impaired. And then if we add intellectual and developmental disabilities or sensory disabilities, all of this gets more complicated, and obviously that affects the internet as well. I want to ask you, Doran, like, how do we tackle this, and who has been involved in discussions around internet accessibility, and who has been left behind?
Yeah, thank you so much. So yes, I think that's a really important question to address, this, the diversity within the disability community. Before that, I just want to say something really, really quick to follow up on Arlene and Blake. I think what's really interesting about this area of disability law more generally, and specifically with regard to internet disability, is how frail everything is. How there's like some kind of frailty, this dangerousness, this idea that we might be, risking it if we go back to the Supreme Court, if we go back to the legislator to ever amend the ADA, right? Because the question that I always get from my students is like, Okay, so there was the ADA amendment of 2008. Why didn't you like just amend the ADA to include the internet in it? And the answer is that I got from Arlene and other really important people in the field is that there wasn't the political support for it. They couldn't just open everything up when they discussed those amendments to the ADA, and that it's not that simple. And I just want to like give an example for this frailty of the disability law and disability rights. Just in October 2019, the Supreme Court denied certiorari. They denied discussing a case called Robbers versus Domino's Pizza from the Ninth Circuit that required Domino's Pizza, the chain, to make its websites accessible for people with visual impairments. And when the Supreme Court refused to take this case on, there was a huge, you can literally hear the huge relief, right? Sigh of relief from a lot of disabled people and a lot of people in the field of accessibility and internet accessibility, because people thought that the Supreme Court, as it stands today, might be hostile to this idea to make private businesses make their website accessible for people with disabilities, right? It might not just be the right climate. So it's kind of absurd. It's kind of like sad. It's not absurd. It's just sad. It's very realistic. It's actually not absurd at all that disability rights advocates would like us to remain in the realm of a circuit split, then risking taking those cases to the Supreme Court and get an unfavorable ruling. So I think that's a really interesting thing that's going on with disability rights more generally, right? So there's all these discussions about disparate impact and the ADA that that a lot of us are really terrified that the Supreme Court will actually take on and dismantle. But it also exists here in this field of internet and disability. And now,
Doron, can I do a two-finger interject before you move on?
Yes.
I just wanted to underscore, like, I completely agree on the cause lawyering part of it, right? You've identified that thread of the disability literature as well, I think, in some of your work. I was also going to underscore legislation is really hard in this space too, because the technocracy or the professionalism of internet accessibility, to use the terms from your work, has gotten so complicated, right? When you think about what does it mean legislatively to try to rope in all of the concepts of the internet explicitly into a bill. One of the beautiful things about the ADA is the simplicity, right? It's a non-discrimination law, right? And what aspects of society should it apply to? All of them. And we have a device for sorting out sort of how that applies. And I think likewise at the FCC, we have this long-running vein of professional or technical expertise that sort of drives how that goes. When you have to go and try and reduce that to all those concepts to legislation, we live in a way more complicated world than we did 30 years ago, technically speaking. And just doing that right in the midst of the techlash and amidst the fights about antitrust and privacy law and all of the other conversations that are happening as part of this series that we're taking part in, it is diving into some uncharted and choppy waters that are that way for reasons that have nothing to do with disability law.
Yeah, I really appreciate the input on like how technology seems to go faster than the legal aspects, right? Arlene, what?
So I not only agree with Blake, of course, I go to him for anything about technology because as someone who is very, very passionate about this area, I actually don't know that much about technology. What I do know from my experience, and I feel this, and this might seem silly, but I believe when there's a will, there's a way. And all of my cases, I mean, I sat for a year talking to the top technology people at various streaming companies telling me, we can't do this. We just can't do it. Like what you're asking for is we can't do. A parallel case, we brought a case against the Social Security Administration because they sent notices to blind people, you're going to lose your benefits in print, right? And so, well, you can't do that. They don't even know they got it and they just lost their benefits. And they literally said, the SSA said, you will not only crash the whole system if we try to put in anything in our system about, you know, an alternative format, you'll crash and no one will get SSI. So I just feel like, I think it is a really complicated area, but I think the resistance is not just based on the difficulty. And it's baffling to me that technology is so proud of itself that it can do anything. And yet the resistance to this area is extreme. There's a reason those regulations haven't gotten out.
If I could, Arlene, just to, you know, when we're artificial intelligence, another topic I think of this series and conversation, and when you get the same companies that are doing, you know, indistinguishable from magic technology with artificial intelligence, or at least making claims that it can, and then they get confronted with, well, could you maybe leverage that to ensure all the videos on your platform are captioned, or to make sure that your images are described? And suddenly it's like, our capacity for world dominating technology prowess is out the window, and we suddenly have these impossible difficulties to navigate. I totally agree.
You know, as in like an academic, as the academic theoretical person, and I think we're all are, right? But like as the person who is not clearly a technology person, more a disability studies, disability law person, I really want to highlight, you know, a book that is one of my favorites book. It's by Mary Johnson. It's 2003 book, Make Them Go Away. And that book is, I think, this idea about, you know, trying to ask people with disabilities, can you just make them go away? Can we just, you know, not deal with this right now? And that book was written before the ADA amendment of 2008 in response to Title III accessibility issues. And I think it really, really is fitting to this idea that we didn't really, you know, society might have kind of like got used to seeing more ramps, or, you know what is the concept of accessibility in their head. But I do think there is still a resistance, and like, you know, to do what people might think is like too much, or like, you know, or you know, quote unquote, you know, going out of your way, quote unquote, to do something for others. And I think the internet is, I absolutely agree with what Arlene said and what Blake said. It's really is where we are now, more than I think with physical accessibility, which is obviously far from perfect, right? But I feel like there's even less understanding, less conceptualization of it in people's minds. So I think that's an important and interesting point. So this, you know, it really made me think about the Make Them Go Away book by Mary Johnson. Can I go back to the diversity within the disability community? Okay, let's do that.
Yes, I was just going to ask. I just wanted to mention to you, and you all know this, but the Convention on the Rights of People with Disability is the first document that actually puts physical accessibility of ramps and those kinds of things and internet accessibility on the same level, or information and communication technology accessibility on the same level. So, you know, there might be some progress from the international side. But yeah, please, Doron, please.
Let's talk a little bit.
I would love to hear your thoughts on you know, how diversity and disability affects this issue.
Yeah, and I think, you know, disability is really an interesting community, right? Because it is made up of people with very different type of impairments and very different type of needs, right? And what I also want to make, you know, clear is that like all kinds of scholars, specifically scholars who write about neurodiversity and the neurodiversity movement, and McGuire's book, War on Autism, comes to mind for me. They wrote, but there were many others after her. The book is from 2016. You know, they really made a point about how with neurodiversity, with people who are autistics or on the autistic spectrum, they use the internet a lot. Basically, a lot of the neurodiversity movement is an online movement in a lot of ways, because that is the way people who belong to that subgroup within the disability community feel very comfortable communicating, right? So the internet is very important for those type of people as well. So to me, it's a really interesting case study, because it is a community that requires the internet maybe even more than others. I do think, you know, we're probably going to get to COVID later, but I think COVID really made us all kind of like, you know, feel how important it is to feel included in the, you know, this world that is not a physical world, right? In the meta world or in the on the internet. I think, nowadays people, when they think about accessibility in the internet, they do think about people with sensory disabilities. When I say sensory disabilities, I mean people who have visual impairments or hearing impairments, right? So we described ourselves, right? And we and we try to make, this presentation accessible. I'm going to give another talk today where I use a lot of pictures. I'm going to describe the pictures on the screen for those people. And for people who have hearing impairments, we do have subtitles. And for people who are culturally deaf, we might have ASL, American Sign Language interpretation too. So I think those are things that people think about a lot. I think other issues that might not be as clear to people or might not be as people might not be as familiar with is the type of font that you might be using on your PowerPoint. There are fonts that are easier to read for people with intellectual disabilities or learning disabilities. So that's something that you might want to, think about. Another issue that I think is really important and something in a community within the disability community that is often being left out is people with intellectual developmental disabilities. Those are people, I think Tina mentioned those as well. I think this is a community that is often being looked down at, right? And is not as, a community that participates as often. For those people, trying to make your presentation use simple language, right? And simplifying your argument in a lot of ways is something that I think is very, very important. There is another, way of actually having some kind of simplified language window or a chat of what you are going to say that could accommodate people with intellectual disabilities. That's something that I think, is a really interesting and important one. I'm happy to say, I'm originally from Israel, and Israel has been, kind of trying to go even further in the ADA about those issues. And I'm happy to say that when a lot of television shows, specifically the ones that, broadcast those big events, right? The Independence Day parade or ceremonies or whatever, there is a different channel that actually has a simplified language translation for people with intellectual disabilities. So I think that's a community that people might want to think about a little more. Again, I do think that for people who don't do disability, this whole concept of, describing your pictures on your PowerPoint, describing how you look like is still also, something that people maybe need to get used to.
Thank you, Doron. I'm glad to hear that we can, there's other examples out there that we can learn from. A reminder to the audience, like if you have questions for the panelists, please put them in the Q&A box. We'd be happy to take anything up. But for the panel, you mentioned COVID-19, and obviously we're sitting here on Zoom, right? Talking to each other from all different parts of the country. Can you all talk a little bit more about how these discussions around internet accessibility has changed, or how COVID-19 and the fact that we moved our lives more or less online has impacted these discussions? And also, at least, with some of our partners, there's a lot of, questions around what will happen when we go back to only in-person contact. So Blake, do you want to start with maybe sharing your insights on this question?
Yeah, I'd be happy to. And I like the way I want to frame this, and I love the way Doron talked about how the technological salience of the internet and its various aspects of it and its affordances really differs from community to community. And maybe another way to put that in the context, and COVID gives us lots of examples of this, is that technologies sort of giveth and taketh away when it comes to accessibility, right? And oftentimes it does that in a differential way across different disability communities. And so, Zoom is the perfect example of that, right? So now, 2 years into the pandemic, we have gone from Zoom being our video conferencing more generally being kind of a curiosity that people did sometimes for special occasions as kind of I think this is how we by default gather now in a whole range of contexts, from education to employment to social to et cetera. And with lots of consequences for accessibility, right? So for example, for people with physical mobility disabilities for whom travel was a barrier to participating in in-person events, or for people who are immunocompromised or who have other disabilities along those lines that made attending things in person really hard. This is in one sense, a welcome way of overcoming those barriers, because it suddenly normalizes this experience so that it's the default. Suddenly the accessible version is the default. On the other hand, the introduction of this model has introduced huge new accessibility barriers to a range of folks, including folks who are deaf or hard of hearing, especially in the early days of the shift to Zoom. The captioning functionality that we're experiencing now was not anywhere close to fully baked. The notions of how we get ASL interpreters incorporated into a call. And by the way, a lot of these problems are still not solved. A lot of these are the subject of active debate and policy making and working with these companies. And then on top of that, I think, Tina, the point that you raised is suddenly people are thinking about, well, are we going away from this now? Are we all going to go back to the office? And implicit in those stories that are framed as, are we all going back to the office, is an exclusion of the folks who need this technology to as a way of overcoming the barriers of in-person learning. And I think it underscores that when we have technology that impacts on innovation, but without any sort of driving governance that thinks about accessibility or forces thinking about accessibility on the front end, when we're not making these moves with accessibility in mind, we end up with a fragile state of affairs, as Doron raised earlier, when it comes to people suddenly able to participate more. That can suddenly go away because we're not doing this for accessibility. And likewise, while we continue to do it, we don't address the barriers that some people face using it. So I think we make a mistake in sort of letting internet law and policy conversations or innovation law and policy discussions sort of tag accessibility as a like, oh yeah, and like this is great for accessibility. Like accessibility is this nice positive externality of this thing that we want to do for totally unrelated reasons. And when those reasons change, or sometimes on the front end, we leave accessibility off the table, and that's not a good way to do accessibility policy. Anyway, that's my thought.
Yeah, absolutely. I mean, this idea that, we use it when it's convenient, but we leave it out if it's not convenient, sort of to going back to what Doron said earlier. Arlene, please go ahead.
I think it's so interesting that all the things that the pandemic has shown can be done on the internet and maybe more efficiently. And I was just reading this article, which I can't really summarize for you, and it's not my expertise, but it was so interesting to me that there's all this concern about telemedicine because people can access their doctors and they can do all these things that they normally had to go to the doctor for. And they're really worried that people are going to get, that it's going to overburden. Like one would think logically, oh, telemedicine is going to save money. But they don't think there's a debate because it could really cost a lot more. And they were particularly concentrating on Medicare and Medicaid, that it could cost a lot more because people could access their doctors easier and they could ask those questions and they could have that contact. And I thought that was, here we have discovered that telemedicine, it has its limitations, of course, but it also works for a lot of things. I know I appreciate it, not having to pack up and go to the doctor when, I have something pretty simple to ask, or, for check-in or, a lot of different things. And very much so in the area of mental health. So I thought that was a very interesting debate, that we now know that telemedicine has a lot of benefits, but people are worried about it and then can put an ethical gloss over it, but it's really a money thing.
Absolutely. Doran, do you want to add?
Yeah, just a little bit. I just heard recently, I was on another panel with Liat Ben Moshe, Dr. Liat Ben Moshe, who's a really great disability law scholar who does work on incarceration and disability. And she mentioned how, as a wheelchair user, someone with a very prominent disability, ever since the pandemic started, people never noticed that about her. And that created a lot of, different type of interaction that she wasn't used to. So that is, I thought it was really interesting, and, you probably should ask her and not me about her experience about that. So maybe in another webinar. But to me, that type of comment might, be on the side of optimism, right? Of how, of an equalizer Zoom could be. But I also want to say that, as Blake said, and as Arlene mentioned, it's not always an equalizer. And I'm also really afraid of a backlash against Zoom, kind of like what's going on with telemedicine, right? With us all, with a lot of people trying to get back to normal as soon as possible. And it's also, like something that I think is complicated where we are all now, right? So we are all a little bit sick of Zoom, I think, at this point of our lives, right? So Zoom becomes, maybe associated with not a very positive experience in our lives, not something that we want to go back to. And we might be losing potential for, accessibility and inclusion in the Zoom area as well, right? Something that I also noticed, so that one might be the less optimistic route, right? The more pessimistic route to go. I did want to also mention that recently I saw that Twitter was boosting its use of alt pictures, right, and of a description of pictures on the platform, which I think is a very, very positive thing. So, not to come up as too pessimistic, I also wanted to mention that as well. I wish we would live in a world, right, where like those big gigantic companies would just do it, from their, because they want to be more accessible, right? And sometimes it might be happening, right? But as Arlene mentioned before, and Blake too, I think there is a lot of resistance still, and I'm afraid that because we are now not associating, the pandemic caused us to associate, a lot of like interaction online as not as positive, that might actually bite us in the butt later on.
And Doran, just a quick coda to that is to say, look at what Meta has sort of proposed as the post-Zoom vision of the world, which is that we're all going to be doing these meetings in virtual reality, wearing headsets as little animated avatars, which, whatever you think about that, raises a whole host of unsolved accessibility issues that are are very obviously not even on the radar in the press releases that are coming out. So I think as you sort of as a sort of being wary of technology as the savior here, right? It's like if the people who are building and designing this don't work with, don't employ, don't think about people with disabilities along the way, then any sort of temporary alignment is going to be temporary, right? And it's going to be about all that we have to keep sort of trying to claw back with law and policy.
Absolutely. Yeah. I mean, these questions don't seem to go away. Again, as technology spreads, it seems like there's more and more. Arlene, and then I really want to maybe go to some of the questions and from the audience. The first one is, are there interesting court cases or decisions that we should look to? Arlene, do you have a comment on what we just talked about, or do you want to?
Yes, and it's combined with the answer to the question, because I saw that also.
Excellent. Awesome.
Is what Blake was saying. There are starting to be cases in all these expanding technologies, and there was a case called Panera versus HTC, HTC being they call it the Netflix of virtual reality. And a deaf man brought a case saying, I can't access this virtual reality. And I guess there's thousands of VR content, games, videos, apps, programs, etc. And the HTC came in again and said, oh my God, no, it's not covered. It's not covered by the ADA. It's, and the court is allowing the case to go forward. So I think that's a really interesting development in new technology. There's a lot of things that are happening in the area of kiosks, and the Department of Justice is very active in that area, but it's a whole, as again, we all know just from living in the world that kiosks are proliferating. And so there's a lot of activity in that area, and coverage in that area as well, where there's finding that it does cover the ADA. I mentioned podcasts before, that the Deaf NAD, National Association of Deaf, has brought a case saying we want the transcripts of the podcasts. So, and I was hoping that's covering some of the areas where litigation is proliferating. But as the new technologies develop, so do the cases seeking access. And then I just wanted to mention, because I noticed the time, that, once again, there are bills being introduced in the US Congress to limit people with disabilities access to the courts in this area. And, so once again, as Doran and Blake and all of us have been saying, it's kind of like, well, disabled people, you have to show a lot of things before you get access. And instead of it being like a fundamental right, like everyone else has access, I want access to. And so along with the proactive litigation that's taking place, there are still efforts to limit the ability of disabled people to access the courts.
Thank you. Doran, do you want to add?
Yeah,
cases?
I just want to say, I do a lot of research about perceptions of fakery and perceptions about abuse of law with regard to disability rights, right? So I write a lot about it. And I think it's also very prominent. It's also very prominent in this area. And I kind of want to follow up on what Arlene said. A lot of the time, people who sue, the litigants who actually sue for accessibility, are being seen as greedy, are being seen as someone who's actually doing something wrong, right? Like trying to take advantage of a system in some way. And I think that's a really important thing to say, because it's a narrative that is being used by people who object to those ideas about expanding disability and actually expanding compliance with existing legislation, and trying to paint a picture of those plaintiffs as being, abusers of the law, being greedy, trying to go after money, etc. I want to also suggest another theory that I have in mind really, really quickly about why people are so objecting, or maybe judges are really so objecting to this idea about accessibility. And that's something that I saw also when I do my research on accessibility in the physical realm. And that's the idea of, accessibility, as Blake said before, is a very nuts and bullets type of area. So it really is about, the angle of the ramp, right? Or it's really about the size of the font, right? Or really if that, a function if it works with another function. That seems very mundane and very boring to a lot of judges who feel like it's not about civil rights at all. It's about those very technical, not important issues, right? They fail to see the big picture of it, and they, cling into those, nuts and bullets of it as seen as something that is impossible to do, or is not even an issue of civil rights.
Thank you. Blake, do you want to add to this?
Yeah, love to tag on to a couple of themes that Doran raised. I think one on that professionalization point, I think one thing that, the FCC tradition has sort of confronted for a long time, and that I think the sort of ADA web intersection is now really starting to dig into with the rulemakings of the Department of Justice and the sort of need for that to happen, is those kind of professionalization nuts and bolts. Like, how do we get from aspirational, let's make this accessible, to actually figure out what are all the standards that need to apply? What are all the things that need to be blocked and tackled on every day by the companies that are providing this stuff? How do we get that out? How do we get the building code equivalents out into the world, so that the folks that are building this stuff know what to do? I think that role of professionalization is really important. Doron, on the con issue, on which I always commend your excellent work, another thing that comes up is the need to complain, litigate, fight, seek remedy when things don't work out in terms of accessibility, that often with these internet technologies that we're talking about would self-correct if they happened, if the technology were dysfunctional in that way for a large constituency of the non-disabled user base, right? If the sound on a movie that was being distributed by Netflix was as screwed up as some of the captions are sometimes, Netflix would get destroyed on Twitter in about 10 minutes, right? That doesn't require going and filing a lawsuit to sort out, right? There's some ways in which those things sort out. And so that sort of administration, whether it's litigation, whether it's filing complaints, whatever it is that gets passed on to people with disabilities, I think is a really hard part of the market failure problem. Last thing I wanted to say, just in response to Anne's question on interesting stuff that's coming out, and this is something my clinic is working on, so I don't want to go into too much depth, but I'm excited about, is the FCC is finally making progress on access to communication services for people who are incarcerated. That has been a long-standing gap in both the application of the ADA in carceral facilities. Basic denial of access to communications has been a huge problem, and particularly for deaf and hard of hearing incarcerated people who need access to communication services. And it looks like the FCC is finally starting to take some action and starting to move on that, to make sure that we get VRS, to make sure that we get IPCTS, to make sure that we get all these relay technologies into carceral facilities. So I think there's actually some intersections of these technology conversations with the broader sort of questions around disability rights, and exciting to see some progress on those.
Yeah, thank you. I mean, this is actually a perfect question to kind of wrap up this discussion, excuse me, because I see we're pretty much out of time. Like, what kind of public policy initiative are out there at any level, local, regional, national, or even international, that are doing disability law the right way? So Blake already, Arlene, do you want to go next?
Well, I think, is the time up?
Almost, yes, but we're kind of using this
well, let's just say,
where do we see some positive things happening?
I think that I just want to say, because I think it is a wrap up, is that this is an international movement, that the ADA was absolutely heard throughout the world, that there are a lot of countries that have their equivalent or have adopted the CRPD, which is the UN International Treaty. And the awareness of disability, I mean, you can, is take a country that most people think of as absolutely, just dealing with intense poverty issues, and there's going to be a disability movement. And so, or of course, for what they call first world country. So in that sense, I think that the movement comes first. The concept of civil rights, I'm glad, Doran, I've been teaching at Berkeley Law for over 40 years. I've been training interns that work at my organization. And I always say, don't even tell me about what the code says before you say, this is the bar, equal opportunity. What does it take for someone to get an equal opportunity? If you lose that, you lose the fight. And so if you keep that in mind, then the evolving technologies fit into the rubric of equal opportunity. And that's what the ADA stands for. And that's what the equivalent laws across the country and the CRPD stand for.
Absolutely. Like, it's not just about compliance, right? It's about how can we be most inclusive to everyone, including people with disabilities. So important. Doron, you have the last word.
Yeah, so I was just about to say, I do think, we can wrap up very soon, but I do want to give another shout out. I think it's important to Ali Swang, right, who is doing the Disability Visibility Project, who is a very active person on social media and on the internet. She has this beautiful, wonderful book called Disability Visibility that came out last year. She has another book coming up in 2023. She has a memoir coming this year. And she's also a good friend of mine. And I think what she shows is this hashtag that she and others created together. It was a movement called hashtag Reap the Vote. Is something that if you would look through Twitter, you will see how it unites, how the internet help unites and help disability rights advocacy. And it actually, reached even a national news on election day. It was mentioned on CNN. So I do think there's a lot of power for the disability community online, if only we can get people access for that. So thank you so much. I learned a lot from everyone.
Doron, can I add a quick pandering note to our hosts on this one? I think much in the way that folks like Alice have really brought in the internet to the disability rights and disability justice movements. The increasing willingness of sophisticated internet law conversations like the one that our hosts are putting on here, to acknowledge accessibility as a really critical public good, really critical policy priority in the broader panoply of internet policy issues. I can think of I've been coming to conversations like this one for the last 15 years, and 15 years ago, accessibility would not have been a part of this series. And so I commend the folks in internet law world, including our hosts here, who are doing a more sophisticated job of thinking about and taking accessibility and disability seriously.
All right. Well, thank you so much, everyone, for this excellent discussion. It was really nice to be with you today. David, I saw has put the next event in the chat, so I encourage all attendees to continue the conversation on disability, accessibility, and access. So thank you again for everyone who joined us today, and especially to the panelists and hosts for inviting us today. Have a great rest of the day, and I hope to see you again soon. Thank you all.
Everybody.
Thank you.